Hello friends, welcome to the Point. In today's session, let's discuss about Directive Principles of State Policy. In short, let's call Directive Principles of State Policy as DPSP. The DPSP, they are enumerated in Part 4 of our Constitution from Articles 36 to 51. The framers of the Constitution, they borrowed the idea of Directive Principles of State Policy from Irish Constitution in the year 1937 and which had copied it from Spanish Constitution. And Dr. B.R. Ambedkar, he described the principles of DPSP as novel features of the Indian Constitution, and the Directive Principles, along with the fundamental rights, it contains the philosophy of the Constitution and as the soul of the Constitution. Features of the Directive Principles. The phrase Directive Principles of State Policy or DPSP, it denotes the ideals that the state should keep in mind while formulating the policies and enacting the laws. These are the constitutional instructions, that is the DPSP. It is a constitutional instructions or recommendations to the state in legislative, executive and in administrative matters. And according to Article 36, the term state in Part 4, it has the same meaning in Part 3, which deals the fundamental rights also. I have already explained about this in the fundamental rights video. Therefore, it includes, that is the DPSP includes the legislative and executive organs of the central and the state governments, all local authorities and all the other public authorities in the country. The Directive Principles, it resembles the instrument of instructions which is enumerated in Government of India Act 1935. So as said by Dr. B.R. Ambedkar, the Directive Principles, they are like the instruments of instructions which were issued to Governor General and to the governors of the colonies of British by the British government under the Government of India Act 1935, and these were called as the Directive Principles. The Directive Principles, it constitutes a comprehensive economic, social and political program for the modern democratic state, and they aim at realizing the high ideals of justice, liberty, equality and fraternity, which is outlined in the preamble of our Constitution. So we can say that DPSP embodies the concept of a welfare state and not that of a police state, which existed during the colonial era. The Directive Principles, they are non-justiciable in nature. That means they are not legally enforced by the courts when they are violated. The Directive Principles, though non-justiciable in nature, it helps the courts in examining and determining the constitutional validity of law. The Supreme Court has ruled many times that in determining the constitutionality of any law, suppose if a court finds that the law in the question, it seeks to give an effect to the Directive Principle, then it may consider such a law to be reasonable in relation to Article 14, that is equality before law, or in relation to Article 19, which has 6 freedoms that saves such law from unconstitutionality. Classification of the Directive Principles. The Constitution, it does not contain any classification of Directive Principles, but on the basis of their content and direction, they can be classified into 3 broad categories like socialistic, Gandhian and liberal intellectual. And let's discuss all these principles one by one. Socialistic principles. These principles, they reflect the ideology of socialism and they lay down the framework of democratic socialist state, and this democratic socialist state, it aims at providing social and economic justice and it sets the path towards the welfare state, and therefore socialistic principle, It directs the state to promote the welfare of the people. How it promotes the welfare of the people? By securing social order permeated by justice, social, economic and political, and to minimize the inequalities in income, status, facilities and opportunity. And this has been explained according to Article 38. And Article 39, it directs the state to secure the right to adequate means of livelihood for all the citizens and to secure the equitable distribution of material resources of the community and for the common good. Article 39, it also secures prevention of concentration of wealth and means of production, and it pays equal pay for equal work for men as well as women. And it also secures the preservation of the health and strength of the workers and the children against a forcible abuse. And finally, Article 39 secures healthy development of the children. And Article 39A, it promotes equal justice to provide free legal aid to the poor. And according to Article 41, it secures the right to work, to education and to public assistance in cases of unemployment, old age, sickness and disablement. So, and according to Article 42, it makes a provision for just and human conditions of work and maternity relief. And Article 43, it states to have a secure living wage, a decent standard of life and a social and cultural opportunities for all the workers. And Article 43A, it directs the state to take steps to secure the participation of the workers in the management of industries. And according to Article 47, it directs the states to raise the level of nutrition and the standard of living of the people and also to improve the public health. And these are all the socialistic principles. Now let's discuss about the Gandhian principles. Gandhian principle, this is based on Gandhian ideology and they represent the program of reconstruction which is enunciated by Gandhi during the national movement. In order to fulfill the dreams of Gandhi, some of his ideas were included in Directive Principles and they require the state to organize village panchayats and endow them with necessary powers and authority to enable them to function as the units of self-governments. That is, according to Gandhian principle, they want village panchayats with almost all the necessary powers and authority to function as a self-government, and this has been included in Article 40. Gandhian principle, it promotes the cottage industries on an individual or corporation basis in rural areas. That is, this principle, they want to promote a cottage industries in a rural areas. Either an individual can take up or it can be done on cooperative basis. It promotes the voluntary formation, autonomous functioning, democratic control and the professional management of cooperative society, and this has been included in Article 43B. Gandhian principle promotes the educational and economic interest of scheduled caste, scheduled tribe and other weaker sections of the society, and it also protects them from social injustice and exploitation. This has been included in Article 46. Gandhian principle, it completely prohibits the consumption of intoxicating drinks and drugs which are injurious to humans' health, and this principle has been included in Article 47 of the Constitution. It also prohibits cow slaughtering, calves and other milch and draught cattle and to improve their breeds, and this principle has been included in Article 48 of our Indian Constitution. Liberal intellectual principles. The principles included in this category, it represents the ideology of liberalism. So this principle, it directs the state to secure all its citizens a uniform civil code throughout the country, and it has been included in Article 44. And in Article 45, this principle says to provide early childhood care and education for all the children until they complete the age of 6 years. And Article 48 states that to organize agriculture and animal husbandry on modern and scientific lines. And Article 48A, it protects and improve the environment to safeguard forest and the wildlife. Article 49 states that to protect monuments, places and objects of artistic or historic interest which are declared to be a national importance. Liberal intellectual principle, it directs the state to separate the judiciary from the executive in the public services of the state, and this has been mentioned in Article 50 of our Constitution. And this principle, it also promotes international peace and security, and it maintains just and honorable relations between the nations so that it can foster respect for international law and the treaty obligations. It also encourages settlement of international disputes by the arbitration, and all this has been included in Article 51. New Directive Principles. The 42nd Amendment Act of 1976, it added 4 directive principles to the original list, and they require the state to secure the opportunities for healthy development of children under Article 39. And under Article 39A, it promotes equal justice and it provides free legal aid to the poor. In Article 43A, it takes steps to secure the participation of the workers in the management of industries. And finally, Article 48A, it protects and improves the environment and it safeguards forest and wildlife. And all this additional directive principles, it was added in our Constitution in the 42nd Amendment Act 1976. And the 44th Amendment Act of 1978, it also added one more directive principle, which requires the state to minimize inequalities in income, status, facilities and opportunity, and that has been included in Article 38. Sanctions behind the directive principles. Sir B.N. Rao, the constitutional advisor to the Constituent Assembly, he recommended that the rights of an individual should be divided into 2 categories. First is justiciable and the second is non-justiciable. And this was accepted by the drafting committee. And consequently, the fundamental rights which are justiciable in nature, it was incorporated in Part 3, and the directive principles which are non-justiciable in nature, they were incorporated in Part 4 of the Constitution. Even though the directive principles are non-justiciable, our Constitution makes it clear that these principles are fundamental in the governance of the country, and it shall be the duty of the state to apply all these principles while making laws. The framers of our Constitution, they made the directive principles non-justiciable and legally non-enforceable. Why? Because the country did not possess sufficient financial resource to implement them. And the presence of the vast diversity and backwardness in the country, it would stand in the way of their implementation. And the newly born independent Indian state, with its many preoccupations, it might be crushed under the burden unless it was free to decide the order, time, place and the mode of fulfilling them. The Constitution makers, therefore, taking a pragmatic view, they refrained from giving teeth to these principles. They believed more in awakened public opinion rather in the court's procedure as the ultimate sanction of the fulfillment of these principles. Criticism of the directive principles. The DPSP, it have been criticized by some members of the Constituent Assembly as well as other constitutional and political experts in certain grounds like no legal force, illogically arranged, conservative and constitutional conflict. Let's discuss one by one. No legal force. The directives which have been criticized mainly because of their non-justiciable character, and while K.T. Shah, he dubbed them as a pious superfluities and compared them with a check on a bank, which is payable only when the resources of the bank permits. And Nasiruddin, he contended that these principles are not better than the New Year's resolution, which are broken on the 2nd of Jan. Illogically arranged. Critic states that the directives, they are not arranged in logical manner, based on a consistent philosophy. And according to N. Srinivasan, the directives are neither properly classified nor they are logically arranged. And the declaration, it mixes up the relativity, that is unimportant issues, with the most vital economic and social questions. And in this regard, Sir Ivor Jennings, he too pointed out that these principles, they have no consistent philosophy. Conservative. And according to Sir Ivor Jennings, the directives that are based on the political philosophy of the 19th century England. And Sir Ivor Jennings, he marked that the ghost of Sidney Webb and Beatrice Webb, it stacked through the pages of the text. And part 4 of the Constitution, it expresses Fabian socialism without the socialism. And he opined that the directives, they are deemed to be suitable in India in the middle of the 20th century. And the question whether they are suitable for the 21st century, it cannot be answered, but it is quite probable that they will be entirely outmoded. Constitutional conflict. K. Sandhanam has pointed out the directives that lead to constitutional conflict between the center and the states, and between President and the Prime Minister, and between Governor and the Chief Minister. And according to K. Sandhanam, the center can give directions to the state with regard to the implementation of all these principles, and in case of non-compliance, he can dismiss the state government. Utility of Directive Principles. In spite of its criticisms and shortcomings of Directive Principles, the Directive Principles, they are not an unnecessary appendage to the Constitution. The Constitution itself, it declares that they are fundamental to the governance of our country. And according to M.C. Sethalwad, the former Attorney General of India, the Directive Principles, it confers no legal rights and create no legal remedies, and they are significant and useful in the following ways. And according to M.C. Sethalwad, Directive Principles are like instrument of instructions or general recommendation which is addressed to all the authorities in the Indian Union. The Directive Principles have served as useful beacon lights to the courts. They have helped the courts in exercising their powers of judicial review. And that is the power to determine the constitutional validity of a law. Directive Principles, they form the dominating background to all the state action, legislative or executive, and they also guide to the courts in some respects. Directive Principles amplify the preamble which solemnly resolve to secure to all the citizens of India justice, liberty, equality and fraternity. Directives outside Part 4. And apart from the directives which is included in Part 4 of our Constitution, there are some other directives that are contained in other parts of the Constitution. They are claims of scheduled caste and scheduled tribes to the services. The claims of the members of scheduled caste and scheduled tribes, it shall be taken into consideration. consistently with the maintenance of efficiency, administration, and in making of appointments to the services and post in connection with the affairs of union or state, and this has been included in Article 335 in Part 16 of our Constitution. Instructions in mother tongue. So according to Article 350A in Part 17 of our Constitution, it states that every state and every local authority within the state, it should provide adequate facilities for the instructions in the mother tongue at the primary stage of a children's education, those who belong to minority groups or linguistic minority groups. Development of Hindi language. Article 351 in Part 17 of our Constitution, it states that it shall be the duty of Union to promote the spread of Hindi language, and it should develop so that it may serve as a medium of expression for all the elements of the composite culture of India. And the above directives, they are also non-justiciable in nature, but they are also given equal importance and attention by the judiciary on the grounds that all the parts of our Constitution must be read together. See you in the next session with some other interesting topic. Thank you.